Perfect. So before we get into things, I would like to recognize a few of our founding members of the Atlantic Women's Venture Foundation, or as we like to call it, the AWVF. We have our three Sandpiper general partners, Rhiannon Davies, Kathy Bennett, and Sarah Young, and the chair of the AWVF Board of Directors, Shannon McDonald. They probably will be joining us soon. Today's event is hosted by both the AWVF and Sandpiper Ventures. The Atlantic Women's Venture Foundation helps women entrepreneurs connect with people, organizations, and investors. Working in collaboration with Sandpiper Ventures, they aim to increase the number of female funders through education and connections. Sandpiper is a woman-led venture capital based here in Canada's East Coast, providing a platform where women investors and founders can radically disrupt the venture capital environment. Sandpiper invests in women-led startups in Atlantic Canada and across the country. Both organizations have come together to create this education series to offer expert knowledge to female founders on their entrepreneurial journey. Our session will start with a 20-minute presentation from Catherine Vardy, followed by a Q&A session. So please feel free to either put your questions in the chat or turn on your video and unmute yourself and just go ahead and ask the question. I'll have my eye on the raise hand emoji to make sure that I capture everyone who has a question. So now, what we're all here for, recently retired, Catherine Vardy joined the Canadian Intellectual Property Office in 2015. As an intellectual property advisor from the Atlantic region, Catherine enjoyed working with people to identify and highlight the value of intellectual property. As a network liaison and program manager at Springboard Atlantic, Catherine worked closely with innovative SMEs, small and medium enterprises, universities, and colleges. Catherine also worked at Atlantic Canada as a Research and Innovation Development Officer with the Natural Sciences and Engineering Research Council. With degrees in science and journalism, Catherine also worked on science communications with several organizations, including the Discovery Channel, Fisheries and Oceans Canada, CBC, and several magazines and newspapers. Thank you, Catherine, for joining us today. I see you already have your slide out, so I'll hand it over to you.
Great. And I apologize for some of the background noise. Of course, I'm in the middle of having renovation done, and I told them to try to not make as much noise or keep it as quiet as possible. So fingers crossed. Thanks for the intro. As was mentioned, up until a few weeks ago, I was working for the Intellectual Property Office of Canada. So I have kind of stolen a few of the slides from my previous gig. Anyway, I'll walk you through a hopefully very short presentation, and quickly afterwards, let's get to your questions and answers, because I think that's more dynamic and more interactive to get to what it is you may have questions about or what it is you're wondering about. But to set the stage, I did want to mention how every single business has intellectual property, and I'll try to cover at least some of the basics so we all start off on at the same place. Maybe you already have a lot of knowledge about the different types of intellectual property. Maybe you've already identified what you have, or maybe you're still a bit earlier in the process or the stage, and that's okay too. So in the past, traditional industries like manufacturing or assembly line plants used to have tangible assets, is what you were called. You might own a building, you might own an assembly line, you might have a fleet of vehicles. But now many startups and many businesses that I've interacted with actually have what we now call intangible assets. So it's the value of what is your brand, or what is the know-how, or is it it could be a physical design of hardware, but more and more things are online, virtual, or they're apps on a phone. And we still do have innovation in traditional machines, devices, shapes of products, and those types of things. But all of those together and in different ways represent a form of IP. So it's myth number one is, well, I'm too small or too early stage, or what I'm doing, I have no IP. That's not true. I always say the minute you have a name for your company or your product, you have a form of intellectual property. The minute you have a product or a service to sell, chances are you right away have at least one form of intellectual property. So then it becomes more a case of let's tease out what it is you actually have. So the best way I like to describe intellectual property is think of it as a toolbox with a different set of tools that protect different aspects of your business. What's unique to you and what you're doing with your business. So if I was building a house, or right now I've got renovations going on, we use different tools for different purposes. If I'll continue the house analogy, you're building a business, but let's say you're building a house. Your roofing company is going to use different tools and different products, as will your plumber or your electrician, right? They're different trades, they do different things. So obviously, if I'm building a house, I want an electrician because I want to have the lights and, power to run the internet. I want running water, I want a shower, I want flush toilets, etc. So, and they all form part of my house, but they'll do different things. Well, our intellectual property toolbox is a little bit like that. We've got different tools that are going to protect different aspects of our business. So this is really the meat or the nuts and bolts of what is our toolbox. The first one that every company has, as I mentioned, the minute you choose a name for your company, how are people going to identify you? How are they going to find you online? How are they going to find you if you have a storefront with a sign facing the street, or headquarters somewhere, you're renting a building? That's a form of trademark. So what differentiates you and the products and services you offer from other companies or competitors? So if I walk down the aisle of the grocery store in any one section, I'm going to see lots of brands. So think of a trademark as a brand. It can be for a name, it can be for a logo, it can be for a slogan. If I say, I'm loving it, or if I say zoom zoom, or trying to think of eat fresh, there, three slogans just off the top of my head. Many of you will know which company. You get a picture in your head as to, oh, that's McDonald's, or that's Subway, or that's Mazda. Or ironically, they've shown that if you show people a picture of a whole bunch of different leaves from trees, they won't be able to tell you what kind of tree that came from. But if you show people big brand logos from Nike, from Apple, from any other, say Toyota or Jeep, you will know what that logo looks like. So as consumers, we are surrounded by trademarks, by logos, by slogans, by names, and those are protected by trademarks. So the minute you have a name for your company or a product, it's really important to make sure the coast is clear. And I'll be reviewing that. What are the 5 tools you need to know? And then we'll go through what are the 3 questions you need to ask when you talk about IP. So trademarks are incredibly important. They can also protect an animation. They can protect a sound or a jingle. So they're quite broad and they're very powerful. I would say for the most part, that tends to often be one of the first forms of intellectual property that people will get to protect their name or their logo. Those are often the first 2 steps. What you need to keep in mind with any of these tools, you need to protect country by country. So let's say I'm a startup and right now I'm doing business in Canada. I'm going to register to protect my trademark in Canada. And I might say I want 2 trademarks. I want my name and I want my logo. But in the next 2 to 5 years, I know I want to expand to the US. Again, very common market for many entrepreneurs, or maybe in your case, you're looking at the EU, or a specific country in whether Germany, France, the UK, maybe Australia, take your pick. Every country has their own intellectual property office. And if you're planning to expand, you need to be monitoring two things. Is your name available? Let's say in the US, we'll use that as our example because that's often the next step for many startups. And in some cases, I've talked to an early stage company and they'll say, from a strategy point of view, it's like, well, you know what? I don't have a big market in Canada. Maybe I don't want to protect my trademark in Canada because, yeah, there's a little bit of a market, but if I get squeezed out with that name here, I don't really care. Really, my goal and my focus is the US. Well, there it's really important to make sure your name is available in the US, that your logo is not already taken by a similar company in the US. So trademarks can coexist for separate, very unrelated products. Standard example we often use is Delta. So think of Delta Airlines in the US, but I can also walk into a hardware store and buy a Delta brand kitchen or bathroom faucet. There will not be a confusion in the mind of a consumer, and that's kind of the underpinning test when you apply for a trademark. The examiner is going to say, is this too close? Is it rubbing up against the edges of an existing trademark? So you've always got to bear that in mind. And these trademark data banks of what has the intellectual property office. In Canada, it's CIPO, the Canadian Intellectual Property Office. In the US, it's the US Patent and Trademark Office. There are public data banks of these where you can look this stuff up. You're trying to pick a name. You're either for your company, your early stage, or you're starting to think of a brand or a name for your product. You're brainstorming with either by yourself, your co-founder, or maybe you're up to 3 or 4 employees, and you're like, okay, well, now we really need to name our product. Looking up existing trademarks is really important to see, is that taken or not? And are you rubbing up against the edges? And I can tell you the big brands, if they have something similar, they will often oppose your application or cause you headaches that you don't want to have. I've done consultations with startups who say, oh yeah, well, my name isn't really similar. And I'm like, okay, I'm not a trademark agent, but you might want to rebrand early on as opposed to get too far down that road. So keeping tabs of who's got what is important, and keeping tabs of who has what in your target future markets is important. I've unfortunately worked with entrepreneurs who were fine in Canada, but the minute they want to start exporting to the US, well, guess what? That name is taken. It's either exactly the same name already in use, or B, too similar that you're going to have legal headaches, which nobody wants. So good to keep tabs on some of that. I spend a lot of times on trademarks because the minute you have a name, you have a potential trademark. And I would say it's very important to consider protecting it, to build that fence around what's yours. So these IP tools, they will not eliminate competition, but they are meant to help you protect what is distinctive and unique to you. So IP is not a magic wand where it's going to eliminate all your competition. Otherwise, we'd only have one of everything, right? These tools can't prevent variations of different apps, different phones, any product you use on a day-to-day basis, you're going to have more than one potential offering. You will only be exclusive to the market for so long before others will nip at your heels and come up by your side. So that's trademarks, tool number 1. Tool number 2 is a patent. And lots of times, I'm at a barbecue or, having at a social event with friends, which we're doing again now, and they'll say, hey, you should patent that. Well, sometimes they say that really meaning what they mean is a trademark, and I'm a nerd, so it's like, oh, well, actually, what you don't really want a patent, you want a trademark, because trademark protects your brand. Patent protects usually an invention. Often it's a mechanical device or a methodology in some cases. And the bar to get a patent is very, very high. It has to be new to the world. So if I invent a new top to for a water bottle with a little spigot that flips out, that would probably qualify for a patent potentially, but it has to be new to the world. So it's more for mechanical inventions. Now, in the US, the rules are a little bit different than in Canada. Some people will patent software. Again, the bar is quite high, and we could have a whole presentation just about how do you protect software, how do you protect apps. I'm not going to go into that level of depth. Just know that it exists, and we in the Q&As can talk a little bit more about patenting, and patenting strategy is incredibly important. That's a whole other area, but today we're going to focus on just a quick brief intro of the different tools. So patents again are really good. If somebody invented a new device for a ladder, if somebody developed a manufacturing process to create a new kind of textile, all those types of things would be patentable material potentially. So tool number 3, industrial designs are essentially for the shape of something or the pattern and ornamentation. Again, I keep it real. What are day-to-day things we all use? Chances are you use toilet paper. Chances are you use paper towels. The design stamped on toilet paper or paper towels is distinctive to a particular brand or a company, and they are often protected with industrial designs. It's also used for shoes and footwear. It's used by Lululemon, a number of their yoga pants, their sports bras, their hoodies. It's used a little bit in the fashion industry. The bar is quite high, again, as to the uniqueness of the design. Again, you're falling into new to the world, but maybe it's the packaging on your product. The Toblerone chocolate bar, for example, that triangle, the shape of the packaging and actually the shape of the product. Industrial designs are actually used a lot in the food industry. Shape of a cookie, shape of a chocolate bar, shape of the packaging. If I walk down the aisle of the grocery store and I see a bottle for honey or maple syrup and it's got a unique design, that may be protected with an industrial design. That can give you up to 15 years of protection. And actually, if you become recognized and distinctive by your industrial design, you can then flip that into a trademark under a specific kind of trademark known as a distinguishing guise, kind of a fancy legal term, meaning I recognize this product. So the plaid for Burberry's, a brand of clothing, very high end, is now protected as a trademark. It started out as an industrial design. The front grille on a Jeep vehicle, which looks very different than the front grille on other vehicles, started out as an industrial design. The Toblerone chocolate bar, the Kit Kat chocolate bar, started as industrial designs, are now actually shifted into indefinite renewable protection with trademarks. So that can be a useful tool. So just think, if the shape or design of your product is distinctive, you may want to look at protecting with that. Tool number 4, copyright. Often we think of copyright for books, novels, music, whether that's the notes or the lyrics to music, could be the cover back in the days when we actually physically had CDs or even cassette tapes and vinyl albums, which are now retro and coming into popularity again. But the artwork was copyright. So Copyright is who has the right to copy. Usually it's artistic works. It includes choreography. It includes broadcasting. So if you watch a series on Netflix or you watch a movie, you will see actually often an Interpol warning at the beginning saying, piracy is not a victimless crime. Interpol will get you, as I call it. But it's a form of copyright. Copyright is recognized according to the Berne Convention. There are international agreements signed for these forms of legal protection for the various forms of IP. We're not globally standardized yet. Copyright's pretty close, though. We've got over 180 countries that all agree that copyright should be managed pretty well the same way. It's fairly close, but they all recognize copyright. Now, copyright also rears its head for computer code. So if you do software or you do apps, copyright is important to you because the computer code is considered a literary work and it does offer some form of protection. Then you also get into open source software. So if you've got a digital-based product, app, software, etc., and you're using open source software for some of it, copyright can be problematic or not, depending on the source of it. You have to read the terms and conditions because, again, it affects who has the right to copy or access. So let's say you dip into open source software to run some aspect of your proprietary product or software or service, your SaaS. You may have to give them access to your entire code. So be careful of that. That, again, back in the day, I was giving a whole 1-hour presentation on copyright and IP for software for SaaS-based products. Beware, there are pitfalls. Good to know about them, read up on them. Lots of information and credible sources is out there. Last but not least, our final tool, trade secrets. It's actually not something you register with any IP office. Essentially, I say you lawyer it up. It's what have you done to protect your valuable information. It might be a process. It might be know-how. In the food industry, it might be a secret recipe. So I often get asked, oh, well, can I patent my recipe? Short answer is often you can't for food products. They don't meet the criteria, which is very high. The bar is high. However, could you keep it as a trade secret? Yes, that may be an option. And some food companies have decided to do that. Common examples are, back in the day, Kentucky Fried Chicken used to advertise their secret blend of 11 herbs and spices. They do have to put on labeling for nutrition and in case people have allergies, but they're allowed to just say spices. And we don't know what spices are in there and in what proportions. Another example, depending on how handy you are, I know I certainly use it as a product, is WD-40. So it's a spray lubricant, comes in a can. They could have potentially patented it when it was invented, but a patent is good for 20 years and then it expires. So it's a time-limited offer to give you a head start on your competition. However, a trade secret, as long as you manage to keep it a secret, lasts indefinitely. So WD-40 was protected with a trade secret, as was the Google algorithm, as was the algorithm for the New York Times bestseller list, and a whole lot of other inside or business intelligence for many, many companies is often protected. And for that, you're going to encrypt files. You're going to have companies who get their employees to sign non-disclosure agreements and employment agreements that very clearly say you can't blab, and you share information on a need-to-know basis. In Canada, the two famous court cases related to trade secrets and the fact that some of them were kind of revealed or breached was IMAX for the movie theaters. And that technology, which was strongly protected both by patents, but also trade secrets for the know-how. Some disgruntled employees left IMAX and formed a competition, a concurrent company, and actually got sued and taken to court and sued for damages. And the other one is Gas Tops, which is is sort of half Ottawa, half Dartmouth company, again with know-how, that was deemed to be breached by people who left the company, but they'd signed non-disclosure agreements, and there was trade secret protection measures in place to prevent that. So every company is going to have at least one, if not multiple forms of intellectual property. And you might want to dip into several of these tools. So intellectual property is not something that I'm starting my company, I'm in year 1 or 2, there's no magic number to say, now I'm going to protect my intellectual property. I'm only going to do one thing. Okay, I'm done. I get to walk away. It doesn't work that way. It's actually really good to keep assessing everything you do. Some of you might be familiar with a business canvas or lean canvas, right? You map things out. Oh, I'm going to launch a new product. Well, what needs, I need R&D. Then I need to look at marketing. Then I need to look at what am I going to call? How am I going to distribute it? How am I going to distribute it? Am I going to manufacture it? Am I going to, contract that out overseas? Am I doing it manufacturing here? All of those decisions, if you put this IP lens on it, you need to think, oh, well, I'm having it manufactured by somebody else. Am I getting them to sign a non-disclosure agreement because this is a trade secret? So I don't want them to be able to turn around after they've finished producing my product on the assembly line. Are they going to be able to make that same product and sell it themselves, or do the same thing for the competitors? What protection do I have there? So everything you do, it's always good to think in the back of your mind, which of these tools might I use and how might I use them? At various stages, maybe every 6 months, maybe every 2 months, maybe minimum, I'd say every 6 months. It's good to just take the step back and go, okay, what am I doing now in my company? Would that have any IP implications on what do I need to protect? So that was our tools. There is online an IP inventory checklist to just start identifying what do you have. So it's really hard to read here on the screen. It's a bit small, but do I have a business product or service name? Do I have a customer list or data? Do I have a domain name? So common myth. I registered my company with the province or joint stocks federally. I'm protected. No, you are not. If you did not look in the trademark database, they will, if you check off doing a nuance search, they will do a bit of a search. But I always say having the clearance of your business name from joint stocks or the province does not necessarily give you permission to put that name on a box of a product that a consumer is going to receive, or a sign facing the street for a storefront. You need to check and do a trademark search, because you might also be close and rubbing up against the edges of somebody else's trademark, and that could cause you problems. You could get a cease and desist. And there are many examples where that's happened. Microbreweries and distilleries, those cease and desist lawyers' letters are flying fast and furiously across the country constantly. In Dartmouth, we have a brewery. I won't name them, but they had to change their name. We have lots of restaurant examples. We have lots of examples in many fields where it just got complicated, unfortunately. But there is a checklist that you can use to help you start identifying what you have and what form of IP would that represent that you could potentially use to protect. So we learned about the 5 tools. The different tools do different things and protect potentially different aspects of what's distinctive to you. Strategy-wise, we always need to ask, very first basic question in early days, is the coast clear or did somebody beat you to it? Because the system works on first to file, not first to invent or necessarily first to use. That's a bit of a it depends answer, but it's really important to look things up. So I came up with a new product or manufacturing, way to do something that's innovative. Does somebody else already have a patent that could block me? They may not be manufacturing it and selling it. People say, oh, well, I haven't found my product out there on the market. There may be a reason for that. It may be that Microsoft or Apple or any number of the other big companies bought the patent for that as a blocking strategy. They don't want to manufacture it, but they don't want it out there because it's going to be competition for something they have. So just because it's not out there on the market and you didn't find a patent, you need to pay for a professional patent search if you're in that space. Trademarking, we already talked about that. You need to look and see what's in the trademark database. Is there something identical? Hopefully not. Those are fairly easy to avoid. But is there something close and similar and misleading to a consumer? So Arctic spas versus polar spas could be seen as a conflict. Puts the same image in the mind of a consumer. So a thorough search is worth the time and in some cases the money to pay a professional to assess that. So that's always the first question. Are you going to find one of three things? Either somebody beat you to it, that's not great, but better to find that out really early than once you've invested a lot of time and money and effort. Number two, you might rub up against the edges. That's not the legal term, but you're close enough to something that's there that it's like, yeah, there's a red flag. Then you definitely need professional IP advice to say, when you're talking about patents, that's what's called a freedom to operate search. Did they find patents that are close to what you have that might impinge or be a barrier to you having freedom to operate? Or in the case of trademarks, is there somebody kind of close and it's like, who is it? Is it another small company or is it one of the big companies? The big companies, I'll tell you, they have teams of IP lawyers and experts. They're monitoring this stuff. So they could cause issues for you. When I talk to a microbrewery and they're rubbing close to Molson's, any of the big beverage companies, just don't give yourself that headache. If you possibly can, you probably want to consider rebranding, and sooner rather than later. So third is result. So one, you overlap, that's a no-brainer, you have to change. Number two, you're rubbing up against the edges. It's a danger zone. Number three, coast looks clear, 2 thumbs up, yay. Now, then your next question is, do you meet the criteria to protect with one or several of your IP tools? So coast is clear, then you are going to look at, well, then no, I want to get a patent. I want to get a trademark. I want to register that in industrial design. It looks like the coast is clear. What I've got is unique. Now I really want to make sure I protect it so that I can move forward. Then that then leads you to say, when and where do I need to protect? Patenting industrial designs, they're time sensitive. Don't launch your product. If you think a patent or an industrial design is the tool you need, don't launch. Canada and the US have a 1-year oops factor, as I call it. Other countries don't. The EU has 0. You launched your product and you didn't protect it, or you put it up on your website because you're so excited and you can't wait to get it out there. Well, guess what? You now can't protect it in the EU. So you need to know this stuff. Timing is important. Trademarks, you've got leeway. Trademark, you could have not gotten a trademark in Canada. You're in business for 4 or 5 years. As long as it's still available, you can get your trademark in Canada. You could wait 5 years. You can protect in Canada, wait 2 or 3 years when you're ready to expand to the US. assuming it's still available in the US, good, no problem. Timing's not an issue for trademarks, but it is for other forms. So your strategy and implementation, when and where do you need to protect? That's really important to know about that and have that discussion and map things out. Some things are time sensitive, some are not. Really important to know which ones and have a rough idea of when you might want to do what. My heart would sink when I would have a discussion. I'll give you an example. Boat builder, of all things, but they had an innovative design. They were manufacturing and selling those boats, and aspects of the boat design were crucial to them for 3 years. I get a phone call. Hey, I heard you know about IP. This is before I retired. There's a company now copying me, and I'm losing sales. They didn't register. It was 3 years the product had been out on the market. They couldn't get an industrial design anymore. Too late. Guess what? Really sad, but now there's nothing you can do about it. So had they protected though early on for $400, they would have had that protection. They could have then done cease and desist and sued for damages. Percentage of the sales of that competitor who copied them if they'd had that protection. So hopefully my goal is to help people avoid those circumstances. So how do you find an agent? There is the College of Agents, Patent Agents and Trademark Agents. You have to write an exam and be certified. So they are qualified to do a good search and to put together an application for you to register your IP. You don't always have to have a lawyer. So there's confusion out there about IP lawyers versus IP agents. Many of them are both. So a lawyer obviously has a law degree recognized by the Canadian Bar Association and got called to the bar. They can sue people. They can send those cease and desist letters. They can take people to court. If there's a dispute with registered intellectual property, it goes either into mediation or a court of law. That's how disputes are regulated, because you have a legal right based on your registration to exclude others from copying, from using what you protected. So you can, however, if you want to file a patent or have a patent search done, or you'd like to apply for a trademark or have a trademark search done, you can work with an agent. You don't necessarily need a lawyer. And between us, agents are a little bit cheaper because they don't have the law degree on top of the others. They're a bit like entrepreneurs themselves. They have the expertise. A number of them are entrepreneurs or solopreneurs, and that's what they do for a living. They help entrepreneurs do these searches and help them with filing. And that's available on this website. So the copy of my presentation will be available, and those are links on there that take you to that site to find someone. And ask around via Sandpiper or industry associations or other entrepreneur groups. Who are people using? A free tool that I've used a whole lot, it's fairly intuitive, is called the WIPO. WIPO stands for World Intellectual Property Organization. They have this global brand database. So all the registered trademarks around the world are in this one-stop shop. It's awesome. I really like it, but then I'm a bit of a nerd. But it is fairly user-friendly. You can filter. So if you see here, the top right, you can filter by country. You can filter by status. So is it active or is it dead? Did it lapse? And you don't need to worry about it. There's a really good, under the help tab up at the top, you can do a little tutorial on how to use it. But if you're with your co-founder, or even you've got your first marketing employee, use this as you're coming up with names for things, and just plug in different names, and it'll tell you what country it's protected in, and does someone have exactly what you're looking for. And you can use wildcards, and you can get more sophisticated, but even just a basic search with this can be well worth your time. So that's a useful tool to tap into. WIPO also has, as I mentioned, if you're in the apps or software space, there's a lot of information and detail in there, but there's great toolbox. So if you're into mobile apps, if you're into software, they have toolboxes, learning modules, key contracts, what to look for, how does intellectual property work in your space, because there is so much activity in that area. So WIPO is a very credible source of information about intellectual property. If you want to learn more about trademarks, about patents, around specific topics, I find that to be a very good resource, as is CIPO, the Canadian Intellectual Property website. So those are credible, sources of information. I'm no longer in my role. Originally, I would have said, you can call me if you want a one-on-one. But our client service center, that 1-800 number, will connect you to my equivalents. They are planning to replace me and hire someone to fill my role. At the moment, there isn't someone now in Atlantic Canada, but my colleagues in Ontario and Quebec, so Caroline in Quebec and Dimitru and Alexis in Ontario are booking some one-on-ones, as are a couple of the other members of the team. So if you wanted to have a one-on-one as an entrepreneur and say, this is my company, this is what I'm working on, help identifying what you might have and what some next steps might be, that's absolutely a service that's available to you. And I would call the client service center and ask to be connected to someone, or that you want to book something. So that's the overview of the various tools, and I'm certainly more than happy to answer specific questions and help in any way that I can.
Thank you so much, Catherine. That was great. We all have different, IP is something that we know is important, but we don't kind of know the details about it. So that was a great overview of, specifics of what to be looking out for, timeline actually, because it can be hard to know the right time to sort of start thinking about that. There is a comment by Suzanne in the chat, and she says, I was on a VC call where they expressed that spending money on IP was a waste of money, since if it was ever infringed on, it would be very or too expensive to defend, but to consult a lawyer. Do you have anything to sort of add on that, Catherine?
Sure. I would say it depends. It's a strategy move, right? It depends what you're talking about. If it's your brand and you didn't register the trademark, can you be scooped and somebody push you out? Absolutely. You don't have your trademark. You didn't register it. Somebody else could apply, because it's not, so CIPO, the Canadian Intellectual Property Office, the trademark examiner, who would have been, my colleague, receives this application. And as the federal regulatory body that manages trademarks for Canada, they only have to look in the trademark data bank to see, can we grant this trademark? So let's see, I'll give you a scenario. I didn't register my trademark. I've been running my company under name XYZ. I have my domain name. I registered with the province. Maybe I registered with joint stocks for XYZ. Somebody decides either just to be mean or legitimately, they're like, hey, there's brand recognition, but hey, I noticed XYZ never registered their trademark. I'm going to apply. I'm going to create a competing company in the same space. I'm going to apply for XYZ as a trademark. I'm going to submit that. I'm going to, pay my $400 and some to register a trademark and apply. Not a huge amount of money. And there are squatters in the same way you get domain name squatters. They're going to apply for that trademark. They're going to send it to CIPO. The trademark examiner looks in the trademark database for Canada, says XYZ to do a spa, let's say. Not in there. So nothing that's going to interfere with us as SIPO to award or grant that trademark for Canada as XYZ. Part of the process, and this is the legal system, which you're not probably ever going to have known about, is that trademark will be advertised in the Trademark Journal. Any of you ever heard of the Trademark Journal? Any of you ever look at it? No, because you probably don't even know it exists. It'll be advertised for a 2-month window. Hey, we're SIPO. We're about to grant XYZ for this spa applicant. You have a 2-month window. Speak now or forever hold your peace to get your trademark, to say, I've been using that trademark, common law. I meant to register it, but I never did. Please, SIPO, don't give it. But you've got a 2-month window to do that, and you have to have read the Trademark Journal. So they've now, nobody stepped up. You didn't read the Trademark Journal, because who the heck does, unless you're a lawyer, and the big companies are monitoring who's applying for what, in case it comes close to their brand, and then they're going to be on it. But startups and entrepreneurs, they don't even know this exists. So guess what? That trademark now just got granted. So you have one last kick at the can to oppose it, but guess what? You've got to go to a higher court. You want to talk about spending money? That's going to cost you 18, 20, 30, 40, 50 times more money than having registered your trademark ever would have in the get-go. And unfortunately, that does happen in the same way that people buy domain names because they're like, hey, this is a good name, it's available. So that. Now, if you're talking about patents, we could talk different strategy. Patent, remember I said it's new to the world. I invented a mechanical device. People say, how much does it cost me to get a patent? Well, that's going to depend. It might cost you 20 grand. It might cost you 100,000. If it's a pharma product or medical product, might be hundreds of thousands of dollars. A strategy people use for patenting is, I'm going to publicly reveal it. I'm going to put all the details out on my website. Then it doesn't meet the criteria for new to the world, then nobody can get a patent. So it's going to depend. So the VC may or may not be right. It can be expensive to defend, but it depends, what are you defending? How important is it to you? Are you talking a trademark? I suspect probably not. And for most people, the $400 to $1,000 to get your trademark, I'd say that's money well spent. If you're an NRCI wrap client, they're just launching a new program where they're actually going to help you pay to protect your IP. So there are sources of money out there to help you cover some of those costs. So you've got to assess it, and risk management, and it depends what type of IP, what form of IP. The $400 for that boat builder, I bet you they're wishing they'd registered that. Submit up to 10 pages of drawing, pay $400, boom, you've got 15 years of protection. Guess what? You now have a really big stick that makes defending your IP a heck of a lot easier. It's a lawyer's letter. Yes, it might be couple of $100, but guess what? You can shut them down. So talk strategy.
Oh, that's great. Thank you, Suzanne, for the comment. We do have one more question because I'm being mindful of the time, but Gabrielle has a question. She says, great presentation. Question is, what recommendations do you have for clients trying to protect their IP while engaging in co-development projects where their technology is being used in a third party's product? For example, in big pharma, where proprietary technologies from smaller groups are often made in big brand products.
Good contract lawyer, good non-disclosure agreements. What are you agreeing to? I call it the prenup. Anytime you are working with more than one person, you start out maybe as a solopreneur, what's the prenup? You may break up. What does your prenup say? Who's going to have the rights to what? If you enter into a relationship, whether that be another small company, a co-founder, or a co-founder, you want that from the get-go, or employees or collaborations, get things in writing. So that third-party product, is that an exclusive agreement? So you want to partner with the development, and you want what you've developed to be used. Is that exclusive? Well, guess what? They're going to have to pay you maybe a little bit more for that. Or are you allowed to use the technology that your startup company has developed in a different non-competing field? So you may have come up with something and maybe it's good in pharma or medical, but what about in engineering or oil and gas development, or I don't know, right? But you get my drift. It maybe what you've come up with could be used in very, very different scenarios. Well, then you've got to go back to, how did you protect your IP when you first set up that initial, was it exclusive or non-exclusive? So dot your I's, cross your T's, get good legal advice and legal agreements. They will always point back to what people can and cannot do.
Perfect. Thank you so much, Gabrielle, for the question. I think the bottom line of what I've gathered today is it's never too early to start thinking about how to protect your company and your idea, and the earlier the better, I assume. But this was great. Thank you so much, Catherine. This was such a great way to end the season. This is our final session of our first season of the Founders Essentials Masterclass. We've learned so much about financing to funding to financial management, and this is just a great way to sort of protect the sort of baby that our founders are creating for themselves. So thank you so much, Catherine, for that. And thank you all for being here today. Please look out for a link for a feedback survey to sort of let us know what we could do better, what you enjoyed, and some of the sessions you would like to see in our future events or masterclasses, and also a YouTube link to the recording of the session and actually Catherine's presentation PowerPoint that she shared with us today. So thank you all for being here, and I hope you have a great rest of your week.
Great. Thank you for the invitation, and take care, everyone.
Of course. Bye.
Bye-bye.